Great. So, good evening and welcome to the BCS webinar. And thank you to all our attendees who have joined us for the AGM and waited while we actually had the interval or intermission between the AGM and our webinar this evening. So, for you who aren't on the call, my name is Sinead Dillon. I'm the incoming chair of BCS Northern Ireland for 2020-2021. I'm delighted to be taking the role on for this year. Delighted to welcome our new committee and delighted to welcome you as attendees to our first event of our new year. Also like to extend my thank you to our speakers and panelists this evening who joined us for our event about how Schrems 2 can affect businesses in January 2021. And also the key line of Brexit won't make it go away. So this evening, I'm delighted that we are joined by our panelist, Daniel Aldridge from BCS Policy. We have Paul Eastwood from Two Solicitors and Chiara Rusty, who is a data regulator analyst. Before we start the event, I'd like to go through a few housekeeping points. We have put all your mics on mute for the event to minimize any disruption. The webinar is being recorded, so it will be available for playback later. We will put the link to the audio onto the BCS NI webpage. But we would like you to be involved in tonight's session, and we appreciate that we unfortunately can't do this face-to-face. So we would like to get your participation in a couple of ways. Firstly, we would ask if you have any questions to please enter the questions into the question box on your actual interface. Also, if you have a question that you'd like to ask directly of any of our speakers this evening, if you could include their name, that would really help me and Christine to filter out the actual questions. But also, this is a very interesting topic, and I'd imagine we will have a lot of questions. If we don't cover all the questions, please be advised that we will review them, and we would use these for other events going forward and probably organise another event. I think this might be the first of many events, and also we'll be working with our BCS colleagues across the UK, and there may be other events too that we will be sharing that with as well, because this is more of a collaboration piece because it affects us all. Tonight we want to run a poll as well, because we want to just really give our speakers some insights into our audience, and we'd ask for your support and to participate in answering 3 short questions. So this evening we're going to have 2 sessions. One is going to be, first we'll have an intro from our panelists, and then we'll have a question and answer session. The whole topic about data transfers and transfers between EU and US to all third countries, and also in the upcoming post-Brexit climate, well, post-Brexit when the UK leaves the EU, is going to mandate changes for everybody. I mean, I think what we don't talk about is all the systems that we're currently using and that we maybe don't think about and how this will affect them. For example, this evening to attend the event, we used Eventbrite. There's implications for using that system as we go forward. MS Teams, Microsoft Teams, which we're all using in our day-to-day activities, Zoom, just as a small example of how these tools are going to have to be changed, and our approach and our businesses will be changed due to Schrems. So I'd like to introduce our speakers tonight, and give you a little bit of intro of what they're going to talk about, and then I will run the poll, and then we'll hear from our speakers, which is why you joined us this evening. So firstly, Daniel Aldridge, who is the Senior Policy Manager at BCS. Daniel's going to talk to us about why Schrems is of interest to BCS. He's going to look then at what is the issue here, because I think a lot of people are a bit, it's a grey area, it's not being talked about. So let's just put a little bit of what the issue is and what it does mean for us. as people in IT and people in businesses, people in all the areas, either startups, SMEs, large organizations in the third sector. So it has implications for us all. So Daniel's going to set the scene for us, and we'll move on then to Paul Eastwood, who is Associate Director in the Contracts and Technology Department at Two Solicitors. And Paul is going to outline the legal issues for data transfer. Paul has a wealth of experience in the commercial and contract law and a significant expertise in data protection law. And currently he's working with assisting a wide range of clients on their responsibilities on the revised data protection regime. So we're delighted to have Paul join us this evening and to share what our clients and what work he's doing with his clients, which will be invaluable for us as IT and business users to take away. After Paul, Chiara Rusty, who is an independent academic and data regulation analyst, is going to talk about as she says herself, the impossible predicament of SMEs and businesses without the large, sophisticated legal teams for as a result of Schrems 2. And there's no truer word than that. I do think that having this opportunity to learn about what's going on will be very useful for our members who may not have access to the legal team or who are not aware of how the risks of Schrems and what the no-deal Brexit could mean for UK. So this evening we're going to cover a lot of those very topical areas and to try and demystify what Schrems 2 is, implications of data transfer and Brexit as well. So Chiara is a former research fellow with the Italian CNR and teaching fellow in jurisprudence at the University of Genoa and a research scholar at the Universities of Milan and Edinburgh. Chiara also chairs the BCS Law Specialist Group and is part of the BCS governance team with the PPP committee. So welcome to all our panelists. Thank you very much for joining us this evening. We're delighted that you've given us your time, and we appreciate the time that you share with us. Before we get started, I mentioned to you that we'd like to run a quick poll. So Christine, if you'd like to run the poll there for us. We've got 3 questions here. I'm going to give you a minute or two to actually complete the poll. Can everybody see the poll there? Great. So the first question that we have is, what sector do you work in? And really this is just to give us a little bit of a understanding of the groups who have attended this evening and to understand. So we've put in 5 different categories there: public sector, voluntary or third sector, small, medium enterprise, foreign direct investment companies, or large private organizations. If you just want to select what organization that fits your area, and we see there 69% have voted. At the moment, SMEs are in the lead. Very exciting part. So this is, we wanted to be interactive, so at least it gets people to understand where we are. So it is currently 81% have voted, which is great. At the moment then, so we're very close, 29% public sector, 38% SMEs, and 24% large private organizations. Okay. Okay, so there we go, 81% voted, and we've got 29% public sector, 38% SMEs, 24% large private organizations. So 3-way split, and 5% for FDIs and 5% for voluntary third sector. Okay, Christine, can we get the next question? Okay, great. So the next question is, where is your largest customer base? So is it in NIGB, EU, US, or don't know? And we can see that the numbers are changing as we go through there, which is really good. Nice to see that we get a quick vote in there. 88% have voted. I think we might be on a countdown till the 1 minute. That so it's a 2/3, 1/3, and then 10% nearly for the 10% for US, and 26% EU, and 65. So the majority is definitely NI and GB. So no surprise there, but good to see that we have a proportion in the EU and the US, and great to see there's no don't knows. That's very positive for all our participants and panelists this evening. Okay, great. So that's a good basis for understanding, and it'll help us to focus our answers to cover off those three main areas. Okay, so our third question is, where is most of your data stored? Is it stored in the UK, EU, US, or don't know? So, it's all very close, this one. Half and half, and then half, 50%, and then quarter. So some areas there for people to get understanding of their data, and I think that will be the purpose of this evening. Will definitely help anybody who doesn't know where the data is, and to explain why it's important then to understand that. So thank you very much. I think we've got 88% has all voted, so thank you very much for your participation. It gives us good insights to know where people are coming from and what's of interest to them, and we can focus on that. So I have hopefully delighted to pass over now to Daniel to start the first part of our session, which is to talk about, to hear from our panelists, and then we'll go on to the questions and answers after we've heard from each panelist. So Daniel, over to you. Thank you very much. Okay. All right there, Daniel. Yeah. Okay, we've just lost you, Daniel.
Hi.
Yeah, excellent.
Can you hear me now?
Hear you now. Yep, good to go.
Okay. Hi. Thank you, Sinead. I really just wanted to say thank you to everybody that's actually attending this, because I think Schrems 2 isn't a kind of sexy topic, but it's something that we really need to pay far more attention on. So I think just signing up to this and being aware of it is really, really important for all of us. Also saying thank you to BCS Northern Ireland Committee for actually taking it on, and for Chiara and Paul for their time and commitment to these issues. The issue around Schrems 2, it really needs much greater public awareness and action. And over the past month, Chiara and I have worked quite intensively on a lot of this, and it's been quite difficult and quite like trudging through treacle at times, but I feel like we're moving forward. So it's really great that we've got so much action happening now. And I think it's that word action that we need to keep in the front of our minds about what we can do in all our workplaces and networks to safeguard our businesses and interests in this ever-changing world. I think it's important to start off a bit of context about the BCS and the BCS role in this. I mean, the Chartered Institute for IT is primarily a network. And like any network, it's only as good as its people. And over the past 6 months, it's been amazing to see how BCS members have found the time to continue to work to make IT good for society, whilst we're all facing such huge and unprecedented threats. Like any organisation based on democratic principles and wishing to represent a very diverse group of people, you know, we all work with IT professionals. We know how difficult it can be sometimes. It's like herding cats to try and get a consensus. But we think it's really important, and this is really difficult even under calm times to be doing this, but the way that our membership has continued to contribute and drive forward agendas such as Schrems 2 is really important. And actually, it's one of the reasons why people like me continue to work in organisations like BCS, because the consensus and being able to drive things forward through this in this way is really exciting. So we have, like most membership organisations, we have our challenges to attract and retain members that are engaged and to demonstrate purpose in a rapidly changing world. But when situations like Schrems 2 arrive, it's absolutely where the diverse, tenacious and skilled hive mind of the member base comes into its own. So, of course, other organisations are talking about Schrems 2 and international data transfer and what the implications are for people. But I think through the independence of BCS and the charitable aims of BCS to make IT good for society, we, with our network of regional and specialist groups, have a unique opportunity to drive these messages to those that need them, and to those audiences that would maybe not hear them otherwise, raising the public profile of them. I was actually able to come over last year to the Northern Ireland AGM, and I think we thought then the world had been turned upside down by Brexit. We weren't aware of the looming pandemic and the colossal impact it would have on our lives, so it's totally understandable that managing the situation around Schrems 2 isn't entirely front and centre of an organisation's risk register, right? Indeed, those warning about the impacts of Schrems 2 on the UK's ability to transfer data internationally may appear to be suffering from a bit of a Cassandra complex, where despite warning accurately about the risks and the need for action, the media and industry news cycles are consumed understandably by any number of current existential threats. So what is in the public realm is focused mainly on what large companies are doing to prepare, rather than the risk to SMEs, the third sector, which are often the lifeblood of our economy, especially in areas like Northern Ireland and areas where areas of the Midlands where I'm from, and our communities, and who are in different ways relying on the support of the third sector and SMEs to get us through these current crises. A recent briefing by a corporate lobby group that I was looking at yesterday talked about the practical reality for the legions of attorneys attempting to navigate this labyrinth of Schrems 2. And I thought that was a really privileged statement to make, because the problem is that so many of our businesses and charities are caught up in this perfect storm without even the awareness that they need legal advice, let alone having it in-house. They're all understandably occupied with juggling Brexit and COVID-19, never mind the day job, operating without even noticing that they are transferring data in contravention of the Schrems ruling and potentially liable for the penalties. So it's not surprising there isn't much out there in the public domain. Indeed, I did a bit of desk research over the past couple of weeks, and quite a hefty proportion of the references to Schrems online are referring to Schrems, an Austrian lager, rather than the ECJ ruling. So it just goes to show how high up on the agenda it is. I maybe see this differently to others, but issues such as Schrems 2, I see issues such as Schrems 2 as an opportunity for real corporate social responsibility to be enacted. It's where the business community can and should be championing the mitigation of risk across the economy and civil society. So I think it's brilliant to see this happening today. And a huge thank you to both Chiara, Paul, and indeed BCS Northern Ireland, who have seen that this is an issue that affects our communities and are happy to champion it. If known about at all, Schrems 2 is understandably in the too difficult box at the moment. But it is the responsibility of all organisations with the privilege of access to knowledge and expertise like Chiara and Paul to cascade this and impress upon our communities that we must take notice. That's the commitment from BCS, I think, and we will continue to do that in the coming months as it is needed and try and do what we can. But it's a call of action to all of us. So anybody on this call now, but also anybody that's listening to this as it is posted online, let's continue to have these conversations. Let's continue to make people aware of the things that Chiara and Paul are going to talk about in a second. Share the BCS briefings, the 10 things that you need to do as an organisation to prepare yourselves for Schrems 2 and make sure we're ahead of the game. I'm sure we'll be able to circulate the BCS briefings after that. But that's me. That's my opening gambit.
Thank you very much, Daniel. That's really useful and great to understand the work that BCS are doing going forward. So we would like to hand over to Paul now. Paul?
Yeah, thanks, Sinead, and Daniel as well. I suppose as my position would allow me to do, I'm going to look at this from the legal perspective. And I think it's worthwhile taking a step back and realizing, and just refreshing on why Schrems is an issue, why it impacts us, and particularly why in Northern Ireland we're worried or should be focused on this, and perhaps we're not. So the starting point, the answer to all of life's questions is to consult GDPR, the actual text, and see what it says. The starting point then is the transfers of personal data shouldn't be made outside of the European Union to a third country, which is a pretty broad statement. So we're not allowed to send personal data outside the European Union unless we can rely on certain grounds to do so. Those grounds would be an adequacy decision, binding corporate rules or standard contractual clauses being in place, or we can rely on an exemption. The logic here, and again, the ethos of GDPR, not to be forgotten that it is a data protection, and its very sort of core meaning of that word. It is designed to protect the personal data of the individual that it affects. So GDPR obviously protects personal data very strongly and very well whenever that data is in the European Union. And it wouldn't be coherent to allow all of those protections that are on that data whenever it's in the European Union to be lost whenever the data goes outside of the European Union. So therefore, GDPR steps in and makes sure that the protection follows the data whenever it goes across borders. So looking then at when we can transfer personal data outside of the European Union and what grounds can we rely on to do so. The first one, or the easiest one to rely on, would be an adequacy decision. That's basically a decision by the European Commission that they say, we've looked at this country's laws. They offer a very good protection of personal data and privacy, roughly equivalent to the rules that are in the European Union. And therefore, you can transfer data with that country or with the companies who are in that country without any further steps being taken. So that's the easiest one. The rub of the green here is that only 12 countries have actually had one of those decisions being granted in their favour. So countries including Canada, Japan, New Zealand, Argentina, they're all countries that we can share personal data with. Data can flow as if they were part of the European Union, and therefore trade can flow, and it's a lot easier. However, that becomes an issue because the countries that we share quite a lot of data with that don't fall within the list and haven't had an adequacy decision granted in their favour include the United States, Australia, India, Pakistan, everywhere that we regularly share data with. If they don't have an adequacy decision granted it in their favour, then we need to go and look at another ground to rely on to allow us to send personal data to them. So those other grounds that we could look at, we've got the binding corporate rules, useful for whenever we're coming from a very large organisation that maybe have different branches or multinational entities within different countries, and we can continue to send data from one branch to another. However, those binding corporate rules are expensive and time consuming to put in, and they're also not effective whenever we want to send data to a service provider or a customer, or indeed have one of those organizations send data to us. So we can't look at binding corporate rules all the time. Then we look at the exemptions. Could we rely on those and think, well, I know that there's no adequacy decision. I know this is outside my organization. Can I continue to make this transfer on the basis of an exemption? Maybe. But again, there's a sting in the tail there that those exemptions shouldn't be a solution. There should be more of a one-off, case-by-case basis thinking, in this situation, can I rely on this derogation to allow me to send this personal data? And GDPR and its recitals were pretty clear there that this should be more of an occasional basis to allow those transfers. So again, not always a functioning alternative. So what are we left with? What can we do to allow us to send personal data outside the European Union, or indeed outside the UK post-Brexit? Standard contractual clauses are probably the most common measure that are being used to allow these transfers to continue. Those clauses have been developed by the European Commission. They're slightly out of date, and we're hoping that they'll be updated and slightly more appropriate ones will be produced hopefully by the end of this year, but that sort of remains to be seen. But essentially, those clauses create a contractual link between the data exporter, so say UK company, and the data importer, so the company that's based in the United States, for example. Thank you to Mr. Schrems. We don't have the privacy shield to rely on anymore because Schrems obviously, or the ECJ Schrems case said the privacy shield isn't good law anymore. So an adequacy decision hasn't been granted. Privacy shield doesn't count. It's outside our organization. It's a regular transfer. Okay, we need to look at these standard contractual clauses. And again, the ECJ looked at those clauses and said, yes, they are still functioning and functionable and usable. There might be a different or another category of due diligence that we need to enter into now whenever we're using those clauses and sending data to an importer to consider the domestic law of that importer. And that is the issue that we're grappling with at the moment, is how do SMEs possibly deal with the legal budget to go and look at every data importer's domestic law and think, yes, that is sufficient, that I can still send the data to them on the basis of standard contractual clauses. So that's just one thing that we're working through. We're waiting for the supervisory authorities, the ICOs, the data protection commissioners, or indeed the European bodies, to come up with an answer, because $7 trillion worth of trade flows back and forth across the Atlantic, and we need to have a satisfactory answer that we can continue to send the personal data that allows that trade to follow. So looking at this from an NI lens, why is this specifically a problem for NI? It probably isn't a problem that's specific to Northern Ireland. It is a problem that is particular to Northern Ireland because of the way our companies are based here, the FDIs that have established companies, and the very large footprint of customers and suppliers that the companies based in Northern Ireland or based in the UK have these connections with other companies across the European Union and further afield. So at the moment, for the next sort of 2 months, we're only looking at this through a lens of, I send data outside of the UK, outside of the European Union. What measures do I need to put in place to allow those transfers to take place? However, come 1st of January, Brexit transition period is over. The rules that have applied for for the majority of 2020 fall away, and the UK becomes a third country. So not only do we need to think about when we are sending data outside of the European Union, but we're also thinking about companies within the European Union or the EU 27 sending data to Northern Ireland and us sending data back to them. So there are loads of transfers that we need to consider, and particularly because we need to put ourselves in the shoes of someone in the EU 27 trying to send data to us, an ongoing customer or supplier we have a very good relationship with. We don't want to lose that work. And suddenly they're saying, you're a third country, you don't have an adequacy decision. This is a regular transfer, so we can't rely on an exemption. You're outside our organization, no binding corporate rules. We need standard contractual clauses in place. And at that stage, we're scrambling around and thinking, what is a standard contractual clause? I have a contract, isn't that enough? We need to be putting these things into place now so that come January, we are in a slightly more comfortable position of saying, yeah, I hear you, we are a third country. However, we've already signed up standard contractual clauses between you and I that allows this transfer to continue. Please don't send your business elsewhere, because that'll make a very cold January for a lot of people whenever they realize that they can't continue to do business with customers who they have been servicing or suppliers who have been helping us for a long time. So a very quick example of that, say a company based in Newry, they send data to Galway to be destroyed. They work for a client in Spain who allows them remote access to their personnel files and make sure that all the databases are working and functioning, and that's all great. And then that company also wants to send out some automated marketing emails, and they use MailChimp. So there we've got a transfer from Newry to the data destruction provider in Galway or wherever else. That's a transfer across the border. We're getting access to the Spanish company's personnel files. So the Spanish company is actually transferring us personal data to Newry, because despite us remotely logging in, that is sufficient to be a transfer. We need to think about what measures are in place. And indeed, whenever we send data back to them, that might be another transfer. And then we've got the MailChimp marketing stuff. We're collecting email addresses from across the European Union, across the UK, sending it all to America. How are we doing that? What measures are in place to allow that transfer to take place? So there's 3 or 4 transfers from just a pretty run-of-the-mill day in this company's business. We need to have thought about this beforehand to allow us to continue those transfers. So what is currently being done by companies in Northern Ireland? I suppose the sort of slightly flippant answer is not much. It's a year of headlines. I have a lot of stuff on my plate, Paul. I've been thinking about COVID, been thinking about Brexit. I don't need to think about data transfers. Unfortunately, the answer is yes, we do need to think about transfers. So what action should be taken? Now, step 1, and this will be familiar to anyone who was lucky enough to be doing the GDPR compliance project through this time, maybe 2.5 years ago, whenever GDPR was about to come in. We need to think about the data flows in and out of the organization, thinking what data comes in, what we do with it, where does it get sent, what are we telling people about where that's being sent, and do we have the appropriate measures in place, record tables are up to date. All of these sorts of things flow from the first step being having a good picture of where data comes in and goes out of our organization. And again, one thing that we have seen from the days of GDPR coming in, individuals and companies rightly as well are much more aware of their own obligations and their rights over data. If something goes wrong, the first thing in my experience that individuals will do will say, how much compensation are you prepared to pay me, because I'm about to go and knock on the ICO's door because you have lost my data. So to avoid all of these sort of uncomfortable conversations come January or a bit later, or indeed now, if we haven't turned our minds to these things of how we're sending data to Australia or to America or wherever else, to avoid these conversations, we need to take a good snapshot of our business and figure out, do we need to put in any measures to allow us to continue to do business come 2021? So that's everything that I wanted to pick on, but hopefully that sparked some questions or some thoughts in your minds. It's a good lawyer's trick of peddling fear, but the idea is there's still time to do all of these things, but again, like everything, time ticks on pretty quickly, so we need to do these things now. So we're very happy to encourage questions after Chiara has spoken. So I'm going to hand over to Chiara now, and he's going to discuss the impacts of Schrems 2, how it's evolving, and what this means for businesses on a global scale.
Thanks. Thanks for the introduction, Sinead, and thanks for handing over, Paul. I just want to state a couple of things before I launch into how hard this whole situation is, before we launch into the complaint bit. I just wanted to restate most emphatically that data protection is a non-negotiable obligation, but also a non-negotiable precious value that we all share. And I'll give you an example, because although you might think all of this is remote, protecting somebody's personal data really can save their bacon. It's not just about the fines that you incur, but think of how much, for example, facial recognition is advancing, and we're beaming people's faces across platforms to do online service support, online conversation, etc. And facially recognizable individuals are individuals that are at any point a target for anybody. And if you don't know where that personal data, that biometric identifier is ending up, you think you're sending it to a friendly state. okay, not adequate US, but then the US company sells it to China, and then China sells it to, oh gosh, well, I don't know, a hostile country. We're not far off from having automated weapons that latch onto a target and fire based on facial recognition. This is not science fiction. This is very, very real. So the idea that if you are in charge of somebody's personal data, you have to hold on to it on a leash practically, and knowing at every point where it's ending up, who you're sending it to, and who those people are sending that data to in the whole subcontractor chain is absolutely critical. You can literally have somebody's life in your hands. So personal data is no joke. However, the situation we're in is not easy. It's in, as Daniel said, in the too hard box, so we tend not to think about it. I just wanted to reiterate some of the points that Paul and Daniel made, because when you're given a lot of information, sometimes you can't absorb it all. So I'll pick out some of the things that people find harder to believe. And let me state, this is a repetition, so I'm not saying somebody new, anything new, but just go back to what Paul said about trading with countries across borders. Now, he used the expression, he slipped an expression there, you may have skipped that, you may have missed that, data importer and data exporter. Now, don't think that's a specialist job description. Any business is a data importer and a data exporter, just by virtue of being in business. You can't trade unless you move personal data in and out of your business, in and out of national borders, and in this case across the EU if you trade with the EU. So you are at the same time a data importer and a data exporter. Something else he said, and you might have missed, is that data transfers really encompasses everything in legal definition, both push and pull. And to access a database is to transfer data. Do not forget that. So if you're accessing databases based in the US, for example, you are transferring data to the US. Don't forget what Dan said, that management may not be on top of this at all. You might be wondering, well, if it's so important, I should have heard about it from my line managers, from my board, from a managing director. You will not have, for a simple reason, this is not percolated, has not sort of trickled down from the very, very high level legal world into everyday business world. So do not presume that somebody in the organization already knows the solution, already has this under control. They probably won't. And you're very probably, as an IT professional, the first person to be aware of it. So don't make presumptions. The other thing that you have heard, but I cannot emphasize it enough, give it a name, call it for what it is. This is a risk. Call it third country data risk, call it Schrems risk, whatever you want to call it, but call it something. Give it a line item in your risk register if you have one. And if you don't have one, give it a name and escalate it to the highest level of the organization that is responsible for managing risks. You can't do this on your own. You can't solve this on your own. You're not supposed to. This is a board level risk, and you should escalate it as such. Don't forget that we have produced a briefing with 10 things to do, 10 steps, but also there is a very beautiful map where you can, at a glance, understand which countries in the world are considered adequate. You've heard Paul speak of adequacy. The European Union considers certain countries to have a level of data protection that is comparable, equivalent to that of the European Union, and these have been granted adequacy. There are some other countries which are not adequate but have bilateral data transfer agreements, and other countries that are so-called third countries and have absolutely no bilateral data transfer agreement. So you can see all of this at a glance if you consult the data protection map produced by the French regulator, the French Data Protection Authority, which is called the CNIL, C-N-I-L, CNIL map. And it's an interactive, so you can just click, see which country you're doing business with, and you can see instantly what the situation is in terms of data. So if you can, map your trade flows against these countries, because you can just about assume that if you're trading with them, you're exchanging data, personal data with them. So once you've done that, you're in a good place. You've started to map your data flows against the map of data protection requirements, and you have given this a name, a risk. That said, you're not alone. This is an impossible predicament for every single business. It is especially hard for small and medium enterprises and micro businesses that rely on Facebook for their shop front. That's all they have. They have a Facebook page, or businesses that have startups that have built an entire business on Google Docs or free web-based mail or systems. So these are the ones that will be most stung by the effort required. The impossible predicament is one where everybody shares the pain. You will hear that, you know, the Banking Federation has written a letter, the French health authorities are in a panic because all the French health data, for example, is held on a centralized database hosted on Microsoft Azure. They're in a pickle. So being alone is half the comfort. Knowing that the larger providers are in this can give you a glimmer of hope, in the sense that it is in the larger providers' interest to make sure that the entire ecosystem that relies on them and does business with them is compliant. So you can not rest on your laurels, but certainly push for the larger suppliers that you rely on to become compliant as quickly as possible and do the work for you if you want. In many ways, it's a Schrems 22 situation. You have no other option than rely on certain providers. On the other hand, there is an expectations that they will get the house in order. But the situation is undoubtedly very difficult. There is a fragmented and diverging sort of regulatory approach to this. Just to give you a sense, because it might matter to you if you do business in these countries. For example, the Berlin Data Protection Supervisory Authority has already indicated that it recommends halting all transfers to the US, and even going further, has recommended retrieval, so to speak, repatriation, if you want, of all the data that has been sent and stored in the US. So that's one of the most extreme sort of recommendations that we've come across. Another German Data Protection Supervisory Authority, Baden-Württemberg, has explicitly stated that standard contractual clauses will only rarely meet the requirements of the ECJ, of the European Court of Justice. And that is black and white. So there is no hiding from the fact that you can rely on these contracts, but there are additional measures that you have to take in place. These are hard. You have to make sure that the country you're sending data to, and don't just think of the US, just think the country, could be China, could be Russia, could be anywhere, could be a hostile nation. The country you're sending personal data to has adequate measures to ensure that access by security services to personal data is proportionate and limited to what is strictly necessary, and that individuals have forms of redress in those countries. Now, European individuals whose data is being accessed by security agencies in third countries with no adequate decision, you must be able, as a business, to understand if those laws, if that legal framework is proportionate, limited to what is strictly necessary, and offers redress. Can you do that? obviously very hard to do, very hard to do. If not, what are your options? Either you stop transferring data to that country, or you rely on additional measures. And this is really where BCS and the legal expertise of the hive mind that Daniel mentioned earlier comes into play. These additional measures are discussed. We have no specific indications by the court judgment as to what they are. We have been promised guidelines by the European Data Protection Board, which is the collective sort of body for all of the national European data protection supervisories, that they will be forthcoming, that will produce them. But the common discussion is on strong encryption. Strong encryption, pseudonymization, but most of all, strong encryption. And there is black and white, there is a discussion by the European Parliament in the sense that whatever encryption is used must be able to withstand the cryptanalytic and quantum computing efforts of intelligence agencies. So this is the challenge, this is the level we're at. If you want to keep transferring data and want to rely on encryption, it must be the best, the best that you can. Now, I'm not an expert, but I know that there are experts in BCS, and that's where we could really come onto our own and shine and understand what is happening in the encryption environment. Of course, sorry, Paul, for saying this, lawyers believe in contracts. There wouldn't be lawyers if they didn't. So lawyers will tell you either that another bilateral trade agreement is coming, so Privacy Shield Redux or number 2 is coming, so wait for that. This is what I hear from certain law firms. Others will say, of course, you have to rely on standard contractual clauses, just make them better or whatever. It's, of course, you know, there are legal means, and there are, of course, extreme business decisions like don't trade with that country anymore. That is an extreme position a boardroom might take, and they don't like complex analysis. They just don't like complications. They could come to a very simple conclusion. But as IT professionals, we should really give our best here. And I've done a bit of research. I understand that there is a new trend towards confidential computing and trusted execution environments. Don't ask me what they are because I don't know, but I will want to know, and I will ask you questions. And I actually know that there is a confidential computing consortium spearheaded by Linux, which must be good news. And it's very recent, October 19, 2019. And this is something we should really make headways and waves on. So Daniel, this is your challenge. I think our next briefing should really be where geeks save the day on Schrems. I'm finished. Thank you very much.
Excellent. Thank you very much, Chiara. Thank you very much, Paul. Thank you very much, Daniel. We covered an amazing amount of content in a very short space of time. And I'm sure you've blown a lot of people's thoughts and expanded their thoughts to think, okay, lots to do, lots to think about, and lots of actions. We do have a number of questions here, so I'm conscious of time. We've only got about 10 minutes or so, so I'll address the questions as we can. The first question is for you, Paul. It came from Peter Loams. Paul, my understanding is that if we get third country status, we will not need standard contractual clauses in place with EU member states, but we will need them in place if we exit without a deal.
Yeah, so I mean, obviously we don't know. I haven't checked BBC News in the last hour, but we still don't know what sort of deal is on the cards if we could get one, or if we do get one. So I suppose we are looking at this from the angle of no deal. I think the answer is that the UK government has come out and said that transfers from the UK to the EU 27 post no deal Brexit can continue without without any further measures in place. Essentially, the UK government has given its own equivalent of an adequacy decision for the EU 27, which you would expect. However, the EU 27 hasn't given that commitment yet, or indeed is really expected to at this stage of the day, I don't think, for transfers back across the border from EU 27 to the UK. So that's why we're approaching it from a no deal perspective as such. Hopefully, if a deal is struck, or if there's an adequacy decision granted by the EU in relation to the UK in the meantime, then that would permit the transfers to take place, and it would largely assuage a lot of fears that businesses are having at the moment. But that's crystal ball stuff, unfortunately.
Okay, thank you. Next question is from Patrick Curry. It's quite a long question, so I'll read it very slowly to get to the bottom of it. The UN Special Rapporteur for Privacy Task Force on Privacy and Surveillance, including UK ICO, is of the view that it is the lack of US government explicit supervision of the US security agencies' unfettered access to EU personal data in the US that is the core issue, with BCRs which BCRs cannot address. Other EU directives, such as the Directive EU 2016/680 of 27 April 2016 on the protection of natural persons with regard to the processing of personal data by competent authorities for the purposes of the prevention, investigation, detection, or prosecution of criminal offences, or the execution of criminal penalties, and on the free movement of such data, are of significant relevance and have to be included. Gdpr is only one aspect. Any thoughts on all that?
This is correct. This is absolutely correct. We tend to think about GDPR and we don't think sufficiently of the directive. I can see why that happens, and I can see why something that has regulation status and applies horizontally across 27 countries grabs more attention than a directive that, as you know, is applied by individual countries. I have to admit, I can't see why taking that directive into account changes the equation. It is still an issue which small and medium businesses or anybody cannot control. We are in a situation which the European Union unilaterally has said, if data is to leave the European Union and end up in a third country, we need to know that that data is protected in the third country the way it would be protected in the European Union. And the fact that the intelligence agencies in the US do not have sufficient supervision, it is true, but doesn't change matters. And I would go further and say the fact that the European court has very limited jurisdiction in what it can tell European member states themselves to do or not to do with personal data for security purposes doesn't change the right that that court has to impose, if you want, unilaterally a standard. Now, that creates all sorts of geopolitical issues, creates all sorts of tit for tat in the long term, but provided that every country has a right to do what it needs to do for protecting citizens, and security agencies will always have access to data. The conversation about what is proportionate in that access needs to be had, both internally and externally to the European Union. What the court is doing is starting the conversation. Okay, we started with the US, but the conversation is continuing internally in the European Union. And we must have that conversation. Paul, do you have any views on that?
To be honest, Cara, nothing further to add. I think that was comprehensive, but that might be a bit of a cop-out, or because I was reading the other questions. Apologies.
Okay. Yeah, and there are a number in there from Patrick, which I wonder the best way, maybe these are going to give interest for a future event to shape them on that one. I think potentially I might want to ask a question here in terms of to Paul, like what data protection laws will apply to NI companies from 2021, just so maybe touch a little bit about, is there anything more you want to add on that?
Yeah, well, I mean, it's as much as anything else, it is just an awareness point in relation to data protection law. Obviously, there's going to be the GDPR, and it has its extraterritorial reach as far as anyone in the world, if they're processing data of people within the EU, then they might be caught by the GDPR. We'll also have our amended UK GDPR, which will apply, and it has been amended by domestic legislation. So basically, it brings GDPR directly onto the UK statute book, so that essentially nothing will change, subject to the sort of definitional points. And then we've got the Data Protection Act 2018, which was enacted alongside or at the same time that the EU GDPR came in. And then we've got the normal things that continue to, there are normal pieces of legislation that will continue to apply around the PECRs and or the direct marketing legislation, etc. So again, it's just an awareness that GDPR might be used as sort of shorthand to refer to all data protection legislation, but there is more to it than just that one piece of legislation.
Okay, just for a general here, that another point that it's mentioned that the ICO in Ireland, Helen Dickinson, is a lead DPA in the EU for dealing with the consequences of Schrems 2 strike down. Given NI Ireland daily business and trade, what does the panel think could be done with the Irish DPA to the special benefit of NI citizens and organisations? Any thoughts on that for anybody?
Yeah, well, I'll get the ball rolling on that, I suppose. I think it's a difficult one because we are so intrinsically linked in terms of those
I think we may be having the gremlins for Paul there on that one.
Footprints of our suppliers, customers.
Sorry, Paul. Unfortunately, we're losing you there on that one. If you can hear us. Yeah, I think we've lost Paul on that one. Okay. I think that there are a number of other questions here that I think we'll probably will take them as reference and maybe include them in our actual audio after with that one. Just to recap and to bring the session to a close, I think we have definitely started the conversation. We have definitely brought to mind how critical an issue is upon and coming down the track to every business. And I think there's a few takeaways that we would like to share. I would like to share my thoughts from all the wonderful information that's been shared with us. From Daniel, I think as members, we can work with BCS and leverage content and the information that BCS has created and shared, bring that into organizations. From Paul, he very much showed us, a snapshot of what you need to do and do your data flows, information coming in, coming out, be prepared, start that engagement. And from Chiara, I think that the biggest thing here is that do not assume that somebody else is going to do it. Give it a name. add it to your risk register. If you do nothing else from today's evening, make sure that it is flagged up as a risk and it will be actioned within your organisation. The critical point here is that if you do not have steps in place, you may not be able to do business. We are facing incredibly challenging times. The last thing we want to have to fall out and be unable to do business due to data, where there are so many other challenges, and now is the time to prepare for that. So I think this has been an invaluable use of your time this evening, and I really extend our thanks to Chiara and to Daniel and to Paul for taking the time to share this. I would suggest that this is just the start, and we may want to revisit this again soon. And thankfully for Dan is running with this, and BCS are leading with this as well too. But from our perspective as a committee, we're delighted to have had the opportunity to have this session, and thank our speakers for sharing that with us. For the people who have attended, thank you for your time, and you'll be able to listen back to the conversation this evening, which I think we all will need to do because of all the information that has been shared, and it's definitely a new zone for us. So without further ado, I've all left to say is thank you very much for attending. We will be organising more events. Please keep an eye on the BCS NI web events for future events, and do get in contact with us. So good evening to everybody. Good evening, Cara, Daniel, thank you very much, and we look forward to our next event. Thank you very much.
Please get in touch. Get in touch.
Thank you.
Thank you.
Thank you very much.